In a small print shop on Northwest 11th Street in Washington are the only plain U.S. citizens who know in advance the decisions of the Supreme Court of the United States. The men at Pearson's print shop have been entrusted for more than 72 years with the printing of decisions before they are made public by the court itself. Today, a new revenue is coming to their little shop through the sale of copies of the decisions with which the Supreme Court in the last 2 years has scrapped fundamental New Deal reform. These decisions are causing President Roosevelt to demand that there be placed in the Supreme Court's new $11 million home chairs for 6 new justices he proposes to appoint if the present justices over the age of 70 refuse to retire. 2 blocks away from the Supreme Court, the biggest mail in the history of the Senate's private post office is daily revealing in letters of protest and endorsement the interest of U.S. citizens in the President's proposal. At his second inaugural, the President again faces the Chief Justice of the Court, which upheld only 2, ruled out 11 of his New Deal laws as unconstitutional.
Office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So help me God.
2 weeks later, from the White House, the President reveals his plan to create vacancies on the Supreme Court.
Our difficulty with the court today rises not from the court as an institution, but from human beings within it. But we cannot yield our constitutional destiny to the personal judgment of a few men who, being fearful of the future, would deny us the necessary means of dealing with the present.
In the Senate, a once solid Democratic majority is split. Loud in protest against the President's proposal are seasoned Democrats like Clark of Missouri, Glass of Virginia, Montana's Burton K. Wheeler.
You can say that the privilege of appointing postmasters will not be accorded to me. You can say that I'll get no more projects for my state. You can say what you please, but I say to you and to Mr. Farley and to everybody else that I will vote against this proposition because it is morally wrong, it is morally unsound, it is a dangerous proceeding.
Saluted as the author of a law passed by Congress and signed by the President to adjudicate the nation's labor union disputes is New York Senator Robert F. Wagner. By this act, employers are bound to bargain collectively with an organized majority of their workers. Few weeks later in Aurora, Missouri, begins for the Wagner Act the ordeal of every contested law. Newly organized workers at an Aurora flour mill demand union recognition.
I won't stand for it. I'll close the mills until you're ready to come back as individuals and forget this union business. If you don't recognize our union, you'll complain to the National Labor Relations Board, and they'll prosecute you. All right?
The mill workers' complaint is forwarded to Chairman Madden of the National Labor Relations Board in Washington. Meanwhile, the mill owners, to forestall government prosecution, dispute the constitutionality of the Wagner Act. In the U.S. District Court at Kansas City, they get a ruling.
Congress has the power to regulate commerce amongst the several states. Manufacturing is not commerce, nor any part of commerce. Nothing more firmly is established in constitutional law than that. It is absurd to say that the refusal of the owner of a flour mill to bargain collectively with his employees directly affects commerce amongst the states. In my opinion, This law is unconstitutional.
Then government attorneys take their case to the U.S. Circuit Court of Appeals in St. Paul, are again defeated. Finally, 100 similar cases involving the constitutionality of the Wagner Act stalemate its enforcement. In Washington, U.S. Attorney General Homer Cummings and Solicitor General Reed picked 5 cases for final judgment by the nation's highest court. In a series of 5-4 decisions, the Supreme Court upholds the Wagner Act, and broad New Deal legislation becomes constitutional by the deciding vote of a single justice. Those who agree with the President's plan believe the path of his New Deal legislation can be completely cleared only by circumventing the die-hard conservatives among the Supreme Court's 9 old members. Associate Justice George Sutherland, born in Buckinghamshire, England, 75 years ago. Immigrant to the U.S., he became senator from Utah. Pierce Butler of Minnesota, 71, only Supreme Court Catholic, the Democratic appointee of President Harding. Willis Vandevamper of Wyoming, 78, senior justice, 26 years on the bench. James Clark McReynolds of Tennessee, 75, confirmed bachelor, who, though a Democrat appointed by Wilson, has voted against every New Deal measure. Only 3 justices are pleasing to New Deal liberals. Benjamin Nathan Cardozo, 67, descendant of the Jewish rabbi who officiated at George Washington's inauguration, appointed by President Hoover. Harlan Fisk Stone of New York, 64, former dean of Columbia University's Law School, schoolmate of Calvin Coolidge. The oldest justice, Louis Dembitz Brandeis of Kentucky, 80, of distinguished Jewish ancestry, so bitterly opposed as a crusading liberal in 1912 that Wilson dared not appoint him Attorney General, but did appoint him to the court. Holding the balance of power are 2 justices. Owen Josephus Roberts, at 61, the youngest justice, long a conservative, but since this fight began, liberal in 7 decisions. And Charles Evans Hughes, 75, the Chief Justice since 1930, sometimes conservative, sometimes liberal. Today, as the struggle over the Supreme Court membership continues, it becomes certain that while 1937 may see its settlement, by passage of the Roosevelt proposal, by compromise, or by wholesale resignations, the political history of the United States will feel its effect for years to come. Time marches on.